From courtroom drama to landmark rulings that shape our daily lives. Hello everyone, I'm Debojit Das and welcome to Courts Today by LiveLaw, your one-stop roundup of the most important legal developments of the day. If it's happening in the courts, you'll hear it here first. Let's begin. There is no other place to start from than former Chief Justice of India, D.Y. Chandrachud, who has sparked debate with a striking remark during a News Laundry interview. He said that the very erection of the Babri Masjid was a fundamental act of desecration. He argued that if the mosque's construction itself violated history, one cannot ignore that fact while only focusing on later events in the inner courtyard. The comment is surprising because the 2019 Ayodhya verdict, authored by a bench that included Chandrachud, explicitly stated that there was no conclusive evidence that a pre-existing Hindu structure had been demolished to build the mosque. The court had acknowledged the Archaeological Survey of India's findings of underlying structures but stressed that they did not establish demolition or reuse of remains. In the interview, however, Chandrachud insisted that there was adequate evidence from the archaeological excavation and accused critics of cherry-picking history to suit their views. He said the court could not simply close its eyes to what happened historically. But critics argue his remarks go beyond the judgment itself held. They point out that the Ayodhya ruling was supposed to rest on legal principles and evidentiary standards, not unproven historical records. This raises an uneasy question. Should a judge publicly take a stance that appears to contradict a judgment they themselves delivered? Next, in another set of controversial events coming from the state of Chhattisgarh, the Supreme Court has rejected a plea from a former Chhattisgarh judicial officer, Prabhakar Gwal, who was dismissed after he, via his wife, filed criminal cases against a former Chief Justice and another judge of the Chhattisgarh High Court. Gwal challenged his dismissal, arguing procedural unfairness and bias. But both the Chhattisgarh High Court's single bench and division bench had upheld his removal, invoking Article 311(2)(b) of the Constitution, which allows dismissal without a full departmental inquiry when reasonably impracticable and when reasons are recorded. In today's judgment, a bench of Justices Vikram Nath and Prashant Kumar Mishra scathingly remarked that Gwal did not deserve to be in any government service, much less the judicial service. They held his conduct repeatedly making allegations, filing hostile criminal complaints, and bypassing due channels had made him unfit for the role. The court noted that the full court of the Chhattisgarh High Court had recommended his dismissal after considering records, correspondences, and the serious nature of his claims. It found that he had acted deliberately, knew the possible consequences, and his behavior was incompatible with judicial conduct. Next, the Delhi High Court has raised pressing questions about the clash between Islamic personal law and Indian criminal law when it comes to child marriage and criminality. The bench, led by Justice Arun Monga, flagged a recurring conflict under Islamic law. A minor girl who attains puberty might lawfully marry, but under Indian criminal statutes such as BNS and POCSO, such a marriage renders the husband a criminal offender. The court asked, should entire communities be criminalized for following long-standing personal laws? Is it time for legislative clarity or even a uniform civil code, or UCC, that reconciles such contradictions? It suggested that core protections like a universal prohibition on child marriages must be uniformly enforceable while allowing less contentious personal matters to evolve within communities. In the case before it, a man 24 years of age, accused of marrying a minor, claimed the girl was older. The prosecution said she was between 15 and 16. Notably, the girl herself contradicted the prosecution, saying she was in fact 20. The girl had earlier been sexually abused by her stepfather and even gave birth as a minor. The marriage between the current accused and the girl was solemnized under Islamic law. The court observed that in bail proceedings, it is not possible to conclusively determine issues like child marriage, puberty, or even consent. The judge emphasized that Islamic personal law must not override penal statutes enacted to protect minors. The court thus granted bail in this instance, but its larger message is very clear. Legal certainty and protection for children cannot be left at the mercy of personal law inconsistencies. Problems with voter rolls continue as the Supreme Court today dismissed a plea by the Uttarakhand State Election Commission challenging a High Court stay on its controversial circular that allowed candidates listed in multiple voter rolls to contest panchayat elections. The bench of Justices Vikram Nath and Sandeep Mehta pointed, how can you decide contrary to a statutory provision? They questioned the SEC's counsel. The underlying issue traces back to a High Court order staying the SEC's clarification, which had ruled that nomination papers could not be rejected solely because a candidate's name appears in more than one Gram Panchayat municipal body, or territorial constituency. The clarification was challenged as being contrary to Sections 9 subsection 6 and Section 9 subsection 7 of the Uttarakhand Panchayati Raj Act, which explicitly bar dual registration in multiple electoral rolls. The Supreme Court imposed a cost of 2 lakh rupees on the SEC for pursuing the petition. By dismissing it, the court signaled that electoral commissions must align their rules with legislative mandates, not act in conflict with them. This decision, of course, reinforces the fact that candidate eligibility and electoral conduct must adhere to statutory provisions. It's also a reminder, however, even bodies empowered to regulate elections must themselves respect the rule of law. Next, we take a look at a high-stakes insolvency matter coming to a conclusion as the Supreme Court has upheld JSW Steel's 19,700 crore resolution plan for Bhushan Power and Steel Ltd, rejecting challenges from its former promoters and a few creditors. This decision comes after a May 2nd order had directed BPSL's liquidation, setting aside the earlier approval of the plan. Now, a full bench led by Chief Justice B.R. Gawai along with Justices S.C. Sharma and K. Vinod Chandran reheard the appeals and reversed the liquidation directive. One key argument the court made: JSW should not be penalized for reviving a loss-making company. The court observed that JSW had infused large sums of money, modernized operations, and turned BPSL into a going concern. It emphasized that courts must defer to the commercial wisdom of the Committee of Creditors, or COC, letting them decide what works for revival. The bench also said that delay in implementation alone cannot invalidate a resolution plan, particularly when some of the delays stemmed from external issues like regulatory proceedings, like the Prevention of Money Laundering Act. The court warned against allowing objections to unsettle a plan long after it's been approved, as doing so would threaten the finality and stability built into the IBC process. With its ruling, JSW's acquisition is now cemented. From a high-stakes insolvency case to a high-profile matter brewing in Bollywood, as IRS officer and former NCB zonal director Sameer Wankhede has filed a defamation suit in the Delhi High Court against Netflix, Red Chillies Entertainment, Aryan Khan and others over the web series The Bastards of Bollywood. In his suit, Wankhede claims that a character in the show bears resemblance to him and portrays him in a negative, misleading light. He argues that the series was deliberately conceptualized and executed with intent to malign his reputation, especially as ongoing legal proceedings between him and Aryan Khan remain sub judice. He seeks 2 crore rupees in damages, which he says he will donate to Mumbai's Tata Memorial Cancer Hospital, along with a permanent and mandatory injunction to remove or restrain the allegedly defamatory content. Wankhede's plea also points to a scene where a character, after reciting Satyamev Jayate, makes an obscene gesture which the suit claims violate both the Prevention of Insults to National Honor Act 1971 and other relevant laws. Next, we saw the Supreme Court today restoring the Competition Commission of India's 2015 order which penalized the Kerala Film Exhibitors Federation and 2 office bearers for anti-competitive practices. The original order had imposed a 7% penalty on them for refusing to let the Tamil and Malayalam films be shown in certain theatres. Here's how the case unfolded. The Federation was accused of colluding to deny film releases to certain theatre owners, who were the informants here, in violation of Section 3 subsection 1, read with Section 3 subsection 3b of the Competition Act 2002. Which prohibits agreements that limit services or control supply. The Kerala Federation and its leaders challenged the penalty at the Competition Appellate Tribunal, or COMPAT, which let go of part of the penalty. Specifically, it struck down the ban on those office bearers from participating in the Federation's affairs, claiming they weren't given show cause notices. But now the Supreme Court has reversed that. It has held that the notice issued in June 2015, as per Regulation 21 and Regulation 48, was sufficient to hold them liable under Section 27. The court found no fault in the penalty or the directions, restoring the full September 8, 2015 CCI order. It also asked for a compliance report, whether the Kerala Film Exhibitors Federation and those office bearers have followed the orders from 2015. In short, the judgment reinforces that competition law must be applied strongly, even in cultural sectors like cinema too, to protect market freedom and prevent associations from unfairly restricting access to films. And finally, in a divorce matter, the Delhi High Court has clarified that separate petitions by husband and wife to dissolve their marriage cannot be retroactively recast as a mutual consent divorce under Section 13b of the Hindu Marriage Act. The bench led by Justices Anil Kshetrapal and Harish Vaidyanathan Shankar emphasized that mutually agreed in Section 13b requires a pre-existing consensus, not just the coincidence of parallel petitions filed by both parties. The court said that parties cannot simply convert independent divorce suits into a joint petition later on, arguing that doing so undermines the very foundation of mutual consent. It warned against viewing the terms together and mutually agreed as mere formalities because they are central to Section 13B's meaning. In short, mutual consent divorce must begin as one joint consensual effort, not be manufactured from separate individual claims down the road. That's all for Courts Today by LiveLaw. Stay tuned as we continue tracking the cases, controversies, and judgments that define the law of the land. Until next time, visit www.livelaw.in to get a detailed coverage of issues that matter. I'm Debojit Das. Thank you for watching.